Let me tell you a story that sounds unbelievable, but it's real. One of the greatest voices in American history, a woman whose music shaped generations, a woman worth tens of millions of dollars. And after her death, her family ended up in court, arguing over handwritten notes found in her couch cushions. This is the estate of Aretha Franklin, and you can't make this stuff up. I'm attorney Otto, and today we're talking about what went wrong in Aretha Franklin's estate, and more importantly, what would have happened if this exact situation played out under Florida law. When Aretha Franklin passed away in 2018, the world mourned the Queen of Soul. Tributes came pouring in. Her legacy was celebrated everywhere. But behind the scenes, something shocking was unfolding. No formal will was found, no neatly signed documents, no clear estate plan laid out in a binder. Her family believed she had died without a will. Now, for someone of her stature, that alone raised some eyebrows because everyone assumed that wealth equals planning, fame equals preparation. But estate planning does not work that way. It's not automatic, it's not intuitive, and if you don't do it, it's going to come to haunt your family in the long run. So, months after she passed away, handwritten documents started to turn up. One was found in a locked cabinet, another tucked away in the cushion of a couch. Notes written in her own handwriting expressing how she wanted her money to be divided, who should manage certain things, who she trusted. Now, at first, those notes felt like relief for the family, like answers or like clarity. But that relief did not last because there wasn't just one note. There were multiple handwritten documents, different versions, different instructions, different dates. And here's where things unraveled. None of these documents were formally executed. No witnesses, no signing ceremony, no attorney supervision, no clear indication of which one represented her true final wishes. And when millions of dollars and family relationships are on the line, that kind of ambiguity is gasoline on fire. Now, in Michigan, where her estate was actually handled, the law allows handwritten wills under certain circumstances. So the question here wasn't, did she do planning or is it good planning? The question was, which handwritten document reflects her true intent? That question didn't get resolved quietly. It went to court. Family members testified against each other. Experts were brought in. Emotions ran high. And eventually, the decision landed with a jury. Yes, a jury of strangers was asked to decide which handwritten note, including the one found in the couch, represented the true final wishes of one of the most iconic artists in history. The jury ruled that the couch will was valid. So, was this legally resolved? Yes. But emotionally devastating? Absolutely. Because by the time a jury decides your legacy, the damage is already done. Relationships are strained. Trust is broken. And no amount of money can undo that. Now let's pause right here because this is where Florida law comes in. If Aretha Franklin had been a Florida resident, this entire story would have ended very differently. In Florida, unwitnessed handwritten wills, what we call holographic wills, are not recognized, period. Florida law is strict. A will must be in writing, signed by the testator, and witnessed by two people who sign in each other's presence. There is no exception for celebrity, no exception for, well, everyone knew what she wanted. Under Florida law, those handwritten, unwitnessed notes would never have even made it to a jury. They would not have even been debated. They wouldn't have been weighed against each other. They would have been thrown out as invalid on their face. End of story. Which means that if Aretha Franklin had lived and died in Florida with no properly executed will, she would have been treated as having died intestate without a will at all. And this is where the human cost really shows up. When someone dies intestate in Florida, the statute decides who inherits. Not you, not your family, not your friends, not your handwritten notes in the cushion, the statute. That means children inherit in equal shares. A personal representative is appointed by the court, and control shifts away from the person who built the legacy and into a rigid legal framework that doesn't care about nuance, relationships, or family dynamics. And if there are disagreements, and there almost always are, litigation is likely to follow. So let's be clear about what actually went wrong here. The mistake wasn't that Aretha Franklin didn't care. The mistake wasn't that she didn't think about her legacy. The mistake was relying on informal expressions of intent instead of a properly executed plan. Now, let me show you how this could have gone right. Imagine just one properly executed Florida will, signed, witnessed, stored safely, one clear document, clear instructions, a named personal representative. No confusion about which version controls. No family members forced into opposing sides of a courtroom. No jury, no couch cushions, no years of litigation. Just clarity. This is why I say estate planning is not only about money. It's about protecting relationships. It's about making sure grief doesn't turn into conflict. It's about sparing the people you love from having to interpret your intentions while they're still mourning your loss. Because the truth is, most of the people I see in Florida probate court, they're not celebrities. They're everyday families. Parents who thought handwritten notes were enough. People who said, well, everyone knows what I want anyway. People who meant well, but didn't follow the rules. And Florida is unforgiving when it comes to formalities. Intent does not save a defective will. Love does not save a defective will. Fairness does not save a defective will. Only compliance with the statute does. So if you take one thing away from Aretha Franklin's story, let it be this. Your wishes matter, but only if they are expressed in the right way. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.